Thank you. Welcome everyone to House General and Housing. It's the afternoon of April 23rd, and we are going to continue our testimony of S-125, which is a kind of an omnibus labor bill that came to us from the Senate. And we took testimony this morning and will continue that testimony. Also, I just want to let the committee know and the public. We're going to tomorrow consider and potentially vote on Proposition 3 or Proposal 3 tomorrow. We'd like to get it out and at least have the House itself have the opportunity, if we pass it out, to vote on it on May 1. And in order to do that, the law requires that there be 4 days of notice. 4 days of notice. And so what we're going to do is make Monday a token session. So that will count as one of the days and we can vote on Thursday. But that means we have to act no later than tomorrow. Let's proceed. The first witness we have is Kelly Price, who is with us via Zoom. And Kelly, can you hear us?
I can. Can you hear me?
Yes, clear as day. I'm going to ask the committee to introduce itself to you. Let's start.
Sure. Good afternoon, Kelly. I'm Ashley Bartley. I serve Fairfax and Georgia.
Great.
I'm Leonora Dodge. I serve Essex Town and City of Essex Junction.
Joe Parsons, Newbury, Topsom, and Brock.
Hi, Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Debbie Dolgan, St. Johnsbury, Concord, and Kirby.
Good afternoon, Gail Pezzo, Chittenden 20, Colchester.
Hi, I'm Elizabeth Brose, and I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
And I'm Mark Mahalik, and I represent Calais, Plainfield, and Marshfield. So, Kelly, why don't you introduce yourself and tell us what you're here to tell.
All right. I appreciate the time. Thank you for the introduction. My name is Kelly Price. I am down in Brattleboro District. I've been a state game warden for the state of Vermont for just about 23 years. I wear many hats, but I know that this is a limited opportunity as far as time goes, so I don't want to take up too much of your time, especially if there's questions. And I'll leave it at that until I get further instruction of how you want me to proceed.
Well, you do have time, and I think you should just start.
All right. Again, thank you, committee members, for this opportunity. I'm here today to talk about a chronic ongoing issue with all the state law enforcement Group C members that are not state troopers. We're all in the same retirement system, the Group C system. But aside from the troopers, all of the other Group C members are not able to fully retire through their step process within the 20 years that is allotted for that retirement system. And I have been part of the bargaining team for VSEA for over a decade now, I believe, participating in the different contract negotiations with the state. And we have been unable to, for over 20 years, come to an agreement to facilitate the same type of accelerated step process, similar, not exact, but similar to what the state police have, in order for us to fully achieve our steps within our 20-year retirement window. And in brief, what happened was when we were offered Group C and all put into Group C, the state troopers were the only ones to facilitate an accelerated step program. All of the rest of the individuals in Group C were left out. And because of that, we subsidize the troopers Group C system by hundreds of thousands of dollars over the 20-year period, because we have to stay on because we were left in a 30-year pay plan, but a 20-year retirement system. So in just the ask here today is there's really only one solution to this at this point, since negotiations have failed and that we are currently within the NMU bargaining unit under VSEA. That unit consists of roughly 6,000 employees from every spectrum of state government. So we are unable to negotiate our specific law enforcement related issues. So we are asking the committee for some assistance, or a committee for some assistance, in possibly creating our own Group C law enforcement bargaining unit. We still wish to stay within VSEA. It's just that we need our own unit to bargain our own issues, particularly this chronic issue of the accelerated steps, so that we can fully achieve our retirement within our 20-year working retirement window.
Go ahead.
Just so I can provide, I think, some background, this has come up. This is not the first time that this has come up, and Mike Povey had suggested that this bill would be germane enough to maybe look at this as it is a labor bill. So we figured, as we were taking quite a bit of testimony on S-125 today, that is why Kelly is here testifying. And I believe that there is language that we can take a look at if it's something that the committee is interested in discussing.
We have language, or it's been
Yes, I
provided.
can.
Okay. Questions of Kelly? Kelly, I just want to understand a little better. As I understand your testimony, you're part of a rather large NMU bargaining unit. And because it's so large and your interests are so specific, you want to be able to create your own bargaining unit for this Group C. Is that correct?
Yes, sir. That would be a correct assessment.
How many members would be in this Group C?
Roughly, and this is a rough estimate, it would be less than 100, but roughly, I'm just going to roughly say about 80, because it includes airport firefighters, game wardens, liquor control, DMV, state's attorney, investigators, and a few other scattered individuals.
Is there, as I understand it, the Vermont Labor Relations Board is absent legislative action. The Vermont Labor Relations Board is the entity that decides whether to certify a bargaining unit, right?
Unfortunately, I am not an expert in the labor board's practices, but I do believe you are correct that typically the process has been in the past that we would go to the labor board to request this issue to be resolved. And it has been approached in the past through VSEA to do this, and it was denied by the labor board at that time because they said that our group would be too small and it would cause over-fragmentation. And at that time, I understood that. But since that point, as you are probably aware, other small units have been created. Example would be the state's attorneys and some other small, I think it was the sheriffs also, a few of the sheriff's units. So they're even smaller than we would be. So the legislature in those regards thought it was important to let those groups have a voice, similar to what we're asking for.
Thank you. Other questions? Kelly Price. Kelly, thank you so much for taking the time to testify. Much appreciated.
Thank you, committee members, for the time, and I hope I was, sorry if I felt a little rushed. I didn't want to take up too much of your time, but if there's any further questions, please send them to me or forward them, and I will answer them accordingly.
Thank you. Our next witness will be David Nickenberg, the lobbyist at Working Vermont. David, want to come up?
Afternoon, David Mickenberg here on behalf of Working Vermont and the Vermont Building and Construction Trades Council, the unionized construction trades. I wanted to go through a bit of a presentation and maybe a bit of background for the committee's information on what is prevailing wage. Because this section that I want to speak to specifically is the submission of certified payroll relates to our prevailing wage statute. Our prevailing wage statute came about in 1996 and is very much modeled on the Davis-Bacon Act, which is a federal law, which has been around for 91 years, which says that if you receive federal dollars as a construction company, a federal contract, that you will have to pay federal prevailing wage, which is called Davis-Bacon. Vermont and other states out of New England, New Hampshire is the only state without a prevailing wage statute. And Vermont implemented its statute in 1996, and about 2015 updated the statute to provide for the provision of benefits. Prior to that, there had been no benefits included in the pay rate. In federal Davis-Bacon, they include wage plus benefits, an amount for benefits. Until about 10 years ago, Vermont did not include that, and we worked, and I was here working on it with Commissioner Manoli and Wachowski and others to update that law to require the addition of benefits. So just to clarify some things for federal, there's been a lot made about well, one witness called it a range, talked about in this bill of $100,000 to $200,000. To be clear, that is a threshold. So we're not talking about this certified payroll, submission of certified payroll being applied to contracts within $100,000 and $200,000. That is a threshold. So if you're receiving $100,000 out of the capital bill, or if it's $200,000 and 50% of that is from the capital bill, anything above that project. So the idea that this would only apply to those living within that range, I just want to clarify, that's a threshold, not a range. Anything above $100,000 that's funded through the capital, any construction funded through the capital bill, $100,000 or $200,000 if it's 50%, would have to apply Vermont's prevailing wage. And the prevailing wage is a wage that is published different than Davis-Bacon, different mechanism on how it's calculated. Published annually, the Department of Labor puts together a list of how much construction workers should be paid in 3 different areas in the state. Very simple to look at. Anyone can find it, and states very clearly that if you're doing this job, you're paid this amount of money. Just by way of
Just a quick question. I just want to make sure I understand.
Yeah.
The prevailing wage, applying the prevailing wage to anything above these thresholds, is that current law?
current law.
Current.
Law. And just to be clear, we've been told, oh, those thresholds are small. For federal Davis-Bacon, the threshold is $2,000. So if you're receiving $2,000 in federal for construction and $2,000 in federal money, then you have to apply the federal Davis-Bacon prevailing wage statute. So Vermont's much higher than $2,000. Also to note, this idea of submitting certified payroll is not a new concept. It's something that's been around for decades on the federal level. Our contractors, we've heard testimony, the other committee, we even heard it today, that our contractors in the state of Vermont are used to doing this. This is not something new. For every federal job, $2,000 or more, they have to submit very similar certified payroll to the Department of Labor. And the question is, why? Well, for 2 reasons. One, to ensure that workers are being paid what they're legally entitled to be paid. I'll give you an example. For instance, in the state of Vermont, in our prevailing wage law, a helper carpenter would be paid $19.43 as a wage rate, and then you would add another 42.5% on top of that to make up for benefits. If they were in fact a carpenter, they would be paid $28.09. So the thing that we are attempting to do here is to ensure that contractors are paying what they're legally obligated to pay. It's not just there was a discussion about the sort of contract with the construction company as a mechanism of enforcement. Just so you know, there is no mechanism of enforcement. Every other northeastern state that has prevailing wage laws has this provision. So if you go to Maine, they have to do this. This particular proposal was modeled under what they do in Massachusetts. Contractors in all of these states are doing this. They're doing it for federal projects and they're doing it for state projects. But we, for whatever reason, did not have any enforcement of our prevailing wage statute. We just have to assume that everyone is doing what they say they are doing. And let's assume that 90%, 99% of the time they are. And we would hope that would be the case. For that 1% or that 10%, when a worker is not receiving the wage, and frankly, the taxpayers are not, they're not seeing evidence of what a company is legally obligated to do. That's what this is. It's just a check on that.
Question?
Yeah, of course.
So would the employees not have some way of proving otherwise than having to rely on like records that have been kept in an archive or something? Like would a simpler method just be like, look at my pay stubs, or here's my
Sure.
income tax return that shows what, what people were paying me for that small percentage of cases where there was like an egregious, or not egregious, but just a
Yeah, could be. Oftentimes it's difficult for an employee. First of all, they're just getting their paycheck. So not everyone is examining exactly what their rate is. And as we heard the Department of Labor say, there's no collection of that information. There's no repository of that information. That's what we're actually trying to do here, is to create that record so that people can see. But sure, they could, and that's how these cases have come up. Where we work, the folks we work, people have come to us, say, oh, I think we're supposed to get paid this, didn't get paid that. We would then bring it to the attention. As the commissioner of the DOL said, it's a complaint-driven system. So this is just a check on what people are supposed to be doing. This is not a gotcha. And to that effect, just so you know, in the Senate, we had modeled language under state of Massachusetts, which said that the Attorney General should receive this information. There was a concern that felt like law enforcement was getting this information. So we said, okay, we'll take that out. We had heard in the Senate that there was a bill, they took it out. We heard in the Senate there was well, we have to get up to speed on this. We heard that today. The Commissioner, Building General Services, said, well, we can't really do this. AOT has been doing this for decades. So it's, a sister agency would have that type of information. But to accommodate that concern, as correctly pointed out earlier, we said, well, then we're okay with the effective date of this law going into effect a year from now. So to accommodate that ramp up and the needed, for us, when a worker is not receiving what they're legally entitled to receive, and when the state of Vermont is not getting what they're entitled to get, we think that's an urgent issue, but understanding the need to educate and put systems into place, those were changes as the bill was, from what the bill was introduced as to now. So the chair had mentioned sort of the purpose of this previously. The purpose of this is to protect workers. That is the purpose. It's to protect the taxpayers, to get what they're supposed to get from the contractors. It is something which contractors in this state, large and small, have been complying with under federal law for decades. We have, and I'll submit to the committee, we have 3 letters from construction contractors writing in support of this bill. If you wouldn't mind, can I read one into the record and I'll send the rest. It says, I'm writing in support of S125. More specifically, At the time, it was section 11 in the Senate. So we as a contractor in the state support these amendments to further ensure the rights of all workers in this state are protected. Furthermore, we feel these are necessary steps to ensure prosperity for trades workers and to protect the integrity of these state-funded projects and to make sure that taxpayer dollars are being responsibly used. We do not feel these amendments would be a burden and would certainly not be a deterrent to bidding upcoming projects, as we have already have to follow these rules when doing work that falls under Davis-Bacon requirements. We appreciate your time and look forward to your support of these amendments. That's from A. Cooper Mechanical, Cole Mugford. And I'll submit the other letters.
Yeah, go ahead.
How many employees does A Cooper have?
I don't know off the top of my head, but I will check. To that point, I mean, small employer, small obligation. If you have a few if you have a few employees, then your obligation in terms of submitting the certified payroll would be small. You have 3 employees, you would, let's say what now has become the sort of window project. It's a 1-day project. That's one person, one line on the form. And I submitted to the committee for your review, and I think you have it, the form that's required for the state of Massachusetts, pretty straightforward. And so you have one project, you're fixing a window, you're a subcontractor, your contract falls under this threshold, above the threshold. So $100,000 or more, 200,000 or more. And you have to submit your certified payroll and it's a 1-day job, you would submit it once. That's it. So the smaller the project and the smaller the firm, it would be the smaller the burden as far as
It is, and do I understand? I think I understand this. The threshold applies to the contractor, not to the subcontractors, right?
I think that it would apply to it could apply to the sub. It's not clear in the language, but I think if the project is a grant of $100,000 or more, I think it would apply to everyone.
To everyone, yeah.
To everyone. Yes.
Right, yeah.
Sorry, I misheard you. Yeah.
Go ahead.
Let's use the window as an example. Say one person is doing the window. Is the payroll, are we certifying payroll for that one person doing the work? Or would it be all current employees on the payroll at that time of that project? You know,
If you're doing, can you repeat that? I'm not understanding.
if you're a subcontractor, let's say you have 5 different projects going,
Yeah,
but specifically one project is for a window in a building that has met, and the
Yes.
contractor has met the threshold.
Yeah.
As a subcontractor, you then in turn have to certify the payroll.
yeah.
Would it be for that one individual doing the window, or would it have to be for every individual that you currently have on payroll at that time?
Well, it's only for people who are classified as construction workers. There's a clear list of.
Absolutely, but I'm saying.
For that project, if you're not obligated, let's say you're doing non-related projects.
Mhm.
You're doing one prevailing wage project and all your other employees are working on non-prevailing wage project. My read of this is that it would be for that project. It only captures projects that are covered under Vermont's prevailing wage statute.
Only that, in her using her example,
That individual,
only that individual.
correct. If it's a non-prevailing wage project, it would not be covered by the statute. So.
I'll ask questions. I'll let them.
You notice that the annual report from the Department of Labor should be easy to find.
Yes, you just search prevailing wage, state of Vermont.
No.
Oh,
You get a lot of Davis-Bacon, you get a lot of third party service.
I have the link. I'm happy to give it to you. Yeah, yeah.
It's certainly, it's not on the Department of Labor's site, on their homepage, there is a list of,
Yeah. I'm happy to send it to you.
there's a list of reports
Mhm.
that's linked on their front page, but it's not in.
Yeah, this is you can see here, the Vermont State Construction Prevailing Wage Rate Schedule. Yeah, so if you put that in your Google, it probably would come up. So. Did you have another?
I do, but
Yeah.
it's actually related to, well, it's related to Tom's question, and that is that it's two small questions. One is, are the federal prevailing wage and state prevailing wage derived using the same kind of formula?
No, they're derived differently. We had attempted when we were working on updating our prevailing wage statute to harmonize them. In conversations with the legislature and others, they wanted to do something based on a Bureau of Labor Statistics survey, which is different than the Bacon survey. So,
Huh.
yeah.
And does the
Oh,
I'm trying to.
basic needs
basic
budget.
needs budget, B and B?
Yeah.
Yeah.
I can't remember what B and B stood for.
I was thinking, I don't know what.
So, do you know whether the basic needs budget comes into play at all?
I don't believe it does. The Bureau of Labor Statistics is its whole separate. Matt Barowitz at
A summer on it. I know, just for fun.
Matt Barowitz at the Department of Labor, I think, is their economist, and he puts together or compiles the data from the Bureau of Labor Statistics survey. So it's a different,
Okay.
I don't believe that comes in. I don't
Thank you.
believe that comes into effect, yeah. There was also an issue that I think Commissioner Manoli brought up about the state certifying. There's nothing in this bill that says the state should certify anything. This is the contractor certifying that this is attesting to the fact that this is the payroll. So I don't believe that, I mean, I think that was brought up, and I don't want to characterize why, but it seemed to be, in listening to, brought up as a fear that if the state were to have to do this, that somehow that would create another burden. This bill, as I read it, does not do that. So did you have another question?
I do. So my understanding is that you really helped craft this aspect of it, and you helped, or the Senate looked at Massachusetts. And I will be honest, I don't know Massachusetts prevailing wage as well as I probably should in this topic. I'm concerned about record collection.
Mhm.
Currently, the bill says for each employee, the record shall include the name of the employee, address of the employee, the hours worked by the employee, the wages paid to the employee's rate of pay, and the classification of the employee. The licensed trades shall supply proof of classification of journey workers and indentured apprentices.
Mhm.
The records described shall be submitted weekly. So, and kept up to 3 years. Social Security is not included in this, correct? As with Davis-Bacon, you cannot include Social Security. Correct.
Yes,
Okay.
I'm just reading the statute, yeah.
Okay, I just wanted, looking for some confirmation, so I appreciate that. What was do you know the idea of why we would keep it for 3 years and why the record should be kept at all?
Yeah, I mean, I think it's when somebody maybe discovered when they get their taxes later that they've been underpaid from what they thought they were being paid. It's a way in which people can then access those payroll documents to make sure that they're in fact receiving what they, yeah.
Doesn't the employee have a certain amount of responsibility to know what they should be being paid and what they are paid?
Sure.
I mean, shouldn't they be checking their pay stub?
They should, and I would say employers also have a responsibility to pay accurately. And so this is just confirmation for all parties that they're paying what they should be paying. So yeah, I think people have some personal responsibility in this. I'll tell you that sometimes it's hard when you have an employer that's not paying you correctly, or you don't feel that you're being paid correctly, to go to that employer. There's a level of a power differential that exists, and to go to that person and say, well, I think I'm supposed to be making $2 more. And by the way, you didn't add in the 42.5%. And, the level of, it's hard to suss this out, as you heard testimony today, the commissioner of BGS, well, this is a complicated thing for an employee, a construction worker that's focused on working, to then go back maybe at the end of the year, look at their taxes. Okay, wait, I actually should have been paid this much more. To have that information available, I think is critical. And every other state that does this in our region, somehow that these issues that have been brought up, somehow they are able to navigate them. I'll just note that the provisions here in terms of what is supplied, that's what Massachusetts requires to be submitted. So that's where that came from.
What are Massachusetts, Maine, what other state, what other?
Massachusetts, Maine, Rhode Island, Connecticut, New York, the new Northeast states. The state of New Hampshire does not have a prevailing wage statute. And I'll add the biggest law on prevailing wage that requires exactly what we're trying to do here is the federal government for a threshold of $2,000 or more. So.
Hard question, so sorry.
No, happy to answer.
Are Davis-Bacon records, are they public records requestable?
Yes. Yeah. I mean, think about it this way, as there's a variety of statutes that require people that are contracting with the state of Vermont to do what they say they're supposed to be doing. And this is just the assurance that they're doing that. When you contract with the state of Vermont, you decide that you are going to be different than if you're contracting with a private party, that you are going to have some level of exposure that is different.
Yeah, no, I would
Yeah.
agree with that. I think a concern that I have is I think we need to be very clear with ourselves and what our workforce looks like and who our workforce is, and ensuring that we are providing protections for all of our workforce who might not be in a place to have their name out on a record somewhere. And that's a big concern for me, especially in this industry.
Well, just so you know, for the licensed trades, at least, we have a contractor registry where their names and information is publicly available as well. So,
And wages.
I don't think wages, because wages don't come into play in the licensing process. So here.
And that's after,
Yeah,
and that's after $10,000 though, correct?
on the contract registry.
Mhm.
No, I think I could be wrong. I think every licensed trade, but maybe Sarah knows differently. So.
Sarah, just say your name again.
Sarah Mearhoff with the Associated General Contractors. It is if you do $10,000 or more of work in the field.
If an individual that's paid as a licensed trade does $10,000 or more of work.
Yes.
Yeah,
if
so
you're
I
a
think
contractor.
Well, that's a contractor registry. I'm talking about licensed tradesmen that are licensed as electricians, plumbers, and pipe fitters. They also are registered through the Secretary of State's office and, they're a licensed trade, so they have to go through that licensing process. My understanding, I could be wrong, that that's publicly available. So I'm happy to be wrong if I am, so. But yes, you can call on yourself.
Yes, I can. Makes a good point, doesn't it?
We're waiting for Magali to go.
There's not, am I right? This is a record keeping, this thing we're talking about now, this piece of the bill that's a record, it's record keeping. It's not about enforcement. In other words, if someone's being paid incorrectly under the prevailing wage law, they or someone would have to bring some sort of complaint, and then this material would be available as proof.
Correct. I mean, and even specifically, we had wanted originally to have this automatically go to the Attorney General's office, who has concurrent jurisdiction in enforcing our misclassification laws with the Department of Labor. But obviously through the legislative process, that came out. So Right now, it says here, just the record shall be available for inspection by the Commissioner of Labor at any reasonable time or upon request. So the Commissioner of Labor was saying, well, we don't have the capacity to handle all of these records coming into, I believe, I'll go back, to be able to handle that. And nothing in this bill requires.
Here's my question. I'm just trying to understand this. Let's say I'm an employee.
Mhm.
Case A is current law. If I feel I'm being underpaid, misclassified, or whatever, I can bring a complaint to the Department of Labor. I guess the wages and hours.
Wage and hour division.
Right. And they have the power, I assume, to they go to my employer and get the employer's records on what they paid me. How is that different in case B where this is the law?
In terms of the enforcement,
Yeah,
I don't think it is that different. I think this provides a tool for individuals and frankly for the state too, to be able to say this record is wrong, you know?
I mean that the
employee can ask.
The employer's tax records or payroll records are incorrect.
Certified payroll that's been submitted doesn't accurately. So for instance, on the example I use, somebody's being classified as a carpenter helper, but in fact, they should be classified as a carpenter. Well, that's almost a $10 difference.
Right.
And so in that case, this would show, well, they submitted this. And you haven't heard testimony from AOT, but AOT testified in the Senate and said, we regularly do this. We do it for federal projects. We do it under federal Davis-Bacon. And yes, there are times in which we find discrepancies. We resolve those discrepancies.
And we heard testimony today that there's these kinds of discrepancies.
Yeah.
What I'm getting at is, I'm just not sure how it's different after all this record keeping. In other words, Department of Labor can go now, if an employee complains, I assume they would either get subpoena voluntarily or involuntarily, they would get the employer's records. I'm asking this in good faith because I'm assuming that, all these states and all this bureaucratic effort must be for a reason. I'm just not sure I fully understand the difference. In either case, there's no enforcement unless the employee actually complains.
Right.
And when they complain under existing law, I guess the employer has access, the Department of Labor has access to the employer's records.
Mhm.
How is that different than?
Well, I think in other states, and maybe this is where, so when this bill was originally introduced, we had the Attorney General receiving this information so that they could, as they do in the state of Massachusetts, take action to enforce the law. This is a weakened version of that because we no longer have the Attorney General. I'd be happy for the committee to entertain putting the Attorney General receiving this information back to make sure that it is properly enforced by the state of Vermont, to make sure that employers are doing what they're saying they should do. But these records can now be accessed by employees in a way, and they can see, okay, this is what I've been paid. I'll give you there are multiple, as I said, multiple instances in which, and unfortunately he couldn't be here from the plumbers, Alex Potvin from the Plumbers and Pipefitters Union is traveling, he couldn't be here today, but multiple examples in which folks have come to him and said, I think I'm being this, and this would be clear evidence of that. You know what I mean? So you could go to the DOL with clear evidence of that and say, this is a problem. I'm being underpaid under Vermont's prevailing wage statute. So I think this is, as you say, it's not the end all. Is this going to end the problem misclassification? No. Is this helpful information that we have both from the employee's perspective, but also from the state's perspective? Right now, we have a requirement that people pay prevailing wage statutes with no verification other than somebody saying, I'm doing it. And I just feel like this is a good government and good government provision, but also good for workers to ensure that they're receiving what they're entitled to under the law. Right now, there's no other capacity other than, as you said, some, you wake up in the middle of the night and say, I'm being underpaid by 32 cents an hour or 40 cents an hour or $1 an hour. And for a lot of people that are working, that makes a big difference over the course of time. So. But I'd be happy to entertain as an amendment to add in the Attorney General back into this piece. I think that was good. I think that was a good provision.
See, I mean, wouldn't the AG still be in a reactive situation? They don't have, as a practical matter, do they have the people to do anything about this unless there's actually an active
I
complaint?
think part of the concern with the AG is that the AG is a political figure.
Well, whether it's political or law enforcement, my understanding is it could be that it's a political figure. You may have information I don't have, but my understanding was that it was more that it was seen as law enforcement.
Right.
But if they're receiving all of these records, and we see, and we've had instances of serious misclassification in the state of Vermont. For those that weren't here, this is a topic that we have worked on for, I don't want to say decades, but decades, actually. If the AG's office gets all of these records as a routine matter and is able to examine them and see, oh, well, actually, we're cross-checking this with Vermont prevailing wage statute. We see that this is a problem. They have independent authority under our misclassification statutes to go and address that with the employer. So.
Are there situations where the employee complaint is filed on behalf of the employee, but through a labor union?
Yeah.
Is that the common?
I can't say now. I don't know how common it is, but of course that happens. Yes. Yep. Yeah. No, we have been, the labor movement has been at the forefront of trying to end this classification for decades. So absolutely. Yeah.
Any other questions?
Just
Did you have more?
looking at my very neatly
Take your time.
taken notes. Don't think so. I'm happy to come back. Just to the point, I think that the vice chair made around housing and things like that, construction of housing, unless a project is funded by through the capital bill or through the cash account, as the language says, that wouldn't apply. So we're not talking about private sector building of homes. I understand we need to do that and totally support the work this committee has been doing to do that. But this is only applying to projects that come through the capital bill or the cash fund, as the language says, that meet the threshold of $100,000 or more, or $200,000 is 50% from the capital bill. So, and that's of more. That's not a range, it's of more. And under that, if it's a really small project, if somebody's doing a $75,000 project, somebody's doing a $99,000 project, and they're a one-person operation, this wouldn't apply.
So the states that have this,
Yes.
the complaints go through the AG's office. All of them have goes through the AG's office of these states.
No, they have the same mechanism. They can complain to the DOL. The AG piece, I'd have to check on the other states whether they have an automatic referral to the AG, but the state of Massachusetts does. The state of Massachusetts has done a lot of work on misclassification. And so the AG's office there has been deeply involved with that. That's where that language originated from. So.
And if the AOT is already doing this.
AOT is doing this on federal projects. Anybody, yes, exactly. Under federal Davis-Bacon, they are already doing this. They are receiving this. Every contractor, I'll just reemphasize, every contractor in the state of Vermont that does a federal project that's $2,000 or more has to submit certified payroll on a weekly basis, including all of this information, except for the one piece of information that's different from the state of Massachusetts and here is, I don't believe under federal Davis-Bacon, the address is included. So that's one difference. They do that, include that in the state of, in Massachusetts. So, but yes, anyone who works on federal work is required to submit these under federal Davis-Bacon, $2,000 or more.
Thank you.
Also, anything I've said today, which is incorrect, I'm happy to be corrected. So I've been working on this issue for many years, but I don't always get it right. So
Why do we ask for the address?
I think it's a way, you know, I think it's just a general point of contact. You know, if somebody has been misclassified, it's a way to get in touch with a letter through the mail, you know, so. And just so you know, I surveyed folks from the building trades in other states, and this is, you know, generally, at least in their experience, from our perspective, has not generally been an issue of concern, you know, the idea, the sort of, you know, some of the issues that have been brought up, they don't exist, even in places like Maine, which is more equivalent to us than, it's not to say that there aren't people that would not want to have this law in place. I'm sure there are. We've heard from them. There are also those that don't want our federal Davis-Bacon law, which is bipartisan law that's been on the books for 91 years. There are those that do not want that to be in place. We, as the state of Vermont, said we believe that construction projects that are being done in our name by contractors, that people working on those construction projects deserve to have a rate of pay. That pay is set in statute through this survey process. And this is just the one piece of enforcement that would allow us to ensure that that's happening.
Other questions of David? Yes.
I'm so sorry.
No, happy to, I'm here all day. Yeah.
Me too. I'm looking at Mass's weekly certified payroll report form.
Mhm.
And at the bottom, it says all apprentice employees identified above currently registered with the Mass DLS Division of Apprentice Standards. We
We have apprenticeships in Vermont. Apprenticeships are construction workers in training.
so what if somebody is not registered? Like, who would then be liable? Would it be?
I'm sorry, I'm not understanding, not registered
So
with this, I mean, that's
This
Massachusetts.
is Massachusetts. I guess I'm concerned that, say we have a contractor who is employing somebody who isn't licensed. Maybe they say they're licensed and we're looking, and I chose Massachusetts because that's
Yeah.
where we're getting this language from. Who's liable for that? I'm assuming it's,
The employer. Yeah, I mean, you can't practice as a licensed electrician if you're not actually a licensed electrician. You can't pay somebody as a electrician helper if they're a licensed electrician. That's what we're getting at here. This is about transparency, you know, so. But
Okay, any other questions? On the committee? Emily, if you are online, I see your picture, Emily. If you're online, do you have any questions of David? Before we
No,
move to discuss?
I'm here. Thank you.
Okay,
just one last thing, just a point, just a note. I was thinking about Commissioner Manoli was talking about how long she's been working on this issue. I feel like I've been working on it that long too. But just a little fact that it was nice to see Joe McNeil, who was my basketball coach when I was 10 years old in Burlington. So it's always good to see. Yeah. Thank you so much.
thank you. Members of the committee, we have available to us our legislative counsel. And I have a few questions, and I imagine maybe others do too, as a result of this. And she only has till a little after 3, I guess, right? So if it's okay with the commission, I mean, one of the things we have is committee discussion. But since Sophie may have to take off. I thought maybe we should have her available to us next. What would you like? Does that make sense? All right. Sophie, you want to come up and? Sophie's available to ask questions about any aspect. There's sort of these three pieces of this, right? There's the 50% plus one piece for decertification. There's a supervisorial question of supervisors in the Department of Justice. And then there's certification of payroll. And we can discuss each of those here with us, but I'm just wondering before we do whether people have questions of Sophie. And I'm happy to start, but I'm going to defer to others if they. I'm supposed to start. One of the pieces of testimony that we heard was that the number of supervisorial employees in the here in the Department of in the courts is very small, like 4. Would, in your opinion, do you have any opinion at all or thought as to whether something that small would ever be certified? They would have to go through the certification process. Would it be certified?
Right. So Sophie Zadatny for the office.
Not that we, I mean, we could always pass the law and they could find out, but I'm just curious how that seemed very small.
Yeah, so this is Sophie Zadatny for the Office of Legislative Counsel. So usually with the Vermont Labor Relations Board, there are a number of factors that they look at when a group comes forward and is seeking to unionize. So one is community of interest. You know, do the folks in the proposed bargaining unit, do they have a community of interest? Are they similarly situated that it would make sense for them to be covered by the same bargaining contract? Another one is over fragmentation of a unit, like is the unit too small, or you know, are there too many little units? And then they also look at are all the people proposed to be in the unit, are they reporting, you know, is the same person in charge of them? You know, the reporting structure is the same. I don't know the answer specifically to the question. I believe under the Municipal Employee Labor Relations Act, there are units that are quite small in some of our very small little municipalities. So I wouldn't say no, never. Typically under our labor laws, a lot of them are structured around 5 or more employees. But I don't know specifically if there was a group that was of 4, but they're a unique group. So, you know, they have a community of interest. Whether or not the board would find that appropriate, I don't know.
I seem to remember when the testimony, individual testifying kind of ran through these employees. One of them, and you know, they were supervising relatively small numbers of people, but one of them was an IT person and one was accounting. Do you have any experience which indicates whether people who are in IT or accounting are considered, what's the word?
Confidential.
Confidential.
Yeah, I mean, that does happen. I was just going to put that there. So under the Judiciary Employees Labor Relations Act, a confidential employee is an employee as determined by the board who has responsibility, knowledge, or access to information relating to collective bargaining, personnel administration, or budgetary matters that's incompatible with that employee's membership in or representation by an employee organization. So it would be fact specific. But if you had somebody, for example, in finance and accounting, if they have access to financial information that could be beneficial to the union to have, that's where that conflict of interest comes in. And you know, then it's like, no, you've got, you know, you're a confidential employee. For information technology, if somebody has
so-called keys to the kingdom, where they can basically see everything that's all the information that's available electronically. There often can be grounds to say that person's a confidential employee and they would not be included in a bargaining unit. So specifically for the four supervisors that were discussed this morning, again, it would be a fact-intensive question. It sounded as if they don't supervise that many folks, so which suggests maybe they are closer to a supervisory employee under the State Employment Relations Act, but you'd have to look at what their actual job duties are and whether they have sort of inside information, so to speak, that would make them a confidential employee.
I don't want to be the first one asking questions here, but if I am, I'll continue. Have you had any, I mean, in the registration piece, Emily, go for it. I just saw your hand up.
I don't know when is the time to talk about the new piece that we were presented with today. You were about to go into a different section, so just if you want to just let me know when.
Okay.
I just have a few questions on the additional piece that we were presented today.
Go ahead, Emily, go ahead.
Kelly.
Emily, you're breaking up a little bit, but go ahead.
Okay. So for me, can you hear me?
Yes, we can.
Can you hear me okay?
Yeah, excellent.
Okay. So for me, I have a few questions. I mean, there's been other units in my experience that, we've tried to discuss and add that haven't. So I wanted to know, if we do decide to add this with one person's testimony, I guess I'm confused on why there are other units.
Whoops. Are we still online?
We are, but she dropped.
Here she is.
You're back. You said, Emily, can you hear me?
Her audio may be connected.
Yeah, we'll wait.
What I don't understand is why there are other groups that we haven't included too. And so through the committee process and testimony, that's the time to do that. So I have asked the lobbyist as well as why we're getting this now and the delay when the process, takes time and we would have worked on that. So that was kind of, it's not for Sophie, it's just in general. There are other groups that I, of course, would like to add as well, but, this came at the last minute. And if we are going to add it, I would like to talk about it more.
Did you know, along those lines, Sophie, were you sitting with the Senate when it?
I'm not sure. Is the question around the testimony from the judiciary or is it
It's
the
not
other?
a question. She was just commenting that there are other groups as well. And what I'm wondering is, what happened to somebody mentioned that the bill as originally went to the Senate had the assistant attorneys general in it.
So
What happened there? There's a bill on our wall that's a separate bill that had them, but what happened in the Senate?
So in Senate Economic Development, they had 3 separate draft bills that had just a number of different things in. So one was a real omnibus bill, one was a sort of employee rights bill, and one was a labor bill. And S-125 and S-117 were the 2 bills that came out, that were committee bills that came out of the committee. So as part of when they were looking at the draft omnibus bills, including the labor one, that did have the assistant attorney generals in there. So it's just a different approach. I guess different committees handle things different way, but they had a lot of pieces that they talked about, many of which didn't make it into that committee bill that came out.
Do you happen to be familiar with with any of the other ordinances, Massachusetts or Rhode Island or?
No, not specifically. I could certainly research if that's something the committee wants me to do.
Yes, go ahead.
I have a question. I'm actually a little embarrassed to ask, but I'm just gonna ask it anyway. Have we talked about, have we gone over the first part of the language that we have? Like the workers' compensation?
So when I did the walkthrough, what I explained was that there were two bills that came out of Senate Economic Development and out of the Senate. And one of them went to House Commerce, and that was
Thank you.
117.
That's where I was
Okay.
getting myself all sorts of confused.
So they
Follow that up.
But this committee has possession of 125 that has those sections in.
Yeah,
So
We would
presumably the committee would need to at some point agree to take those,
take that out.
Those out.
Take those,
right?
just for the committee. That's section 1 of the bill.
Well, it's sections 1 through 4.
4 of the bill are workers' comp, which is handled by here by the Commerce Committee. For new members like me, who don't remember, the Senate Committee is like the combination of the Commerce Committee here and our committee. I guess I'm not sure how far I want to go with this, but I am curious, I must admit, as to how the regulatory regime works in Massachusetts and in Maine. In other words, is there, one of the realities of our state is that we really don't enforce very much here. We just don't. We don't have the whatever. We don't have the state people working for the state who do this. And so I'm just wondering if that's different from the situation in Maine. And I worked on timber theft last year, and when you look at Maine and their regime for dealing with people who are potentially causing problems as they log, it's so much more developed than ours and runs through their agency, their state agency that deals with forestry and issues. And we just don't do that. And so I was just wondering whether they have regulatory regimes that involve enforcement.
Yeah, I mean, I would, again, I'm not familiar with those. I would say that for Vermont, as you've heard, it's primarily complaint driven. So if there are complaints, they go to the Department of Labor or the Attorney General's office or the Rights Commission, depending on what the entity is, and then are investigated. But it's not, agents going out looking for problems.
Any other questions of Sophie? Yes.
I know we talked about the public records request, how this information would be available. Is that something that we could legislate saying this information wouldn't be available?
Yeah, so the Public Records Act has a list of exceptions within it, but then just through Vermont statutes, there are just a whole host of this will be covered, this won't be covered. I believe that for some of them, it's only for limited periods of time unless you say notwithstanding, whatever. I can look at that more closely, but yeah. So here you would be specifically saying this information is covered. There are exceptions under the Public Records Act regarding personnel information, certainly things like addresses and stuff like that, that would be protected from disclosure.
Okay, I appreciate it.
But I think here, if you have it explicitly saying that it would be covered, I think there'd be an argument that you would have to provide the addresses too.
Okay, anybody else? I don't want to keep Sophie unnecessarily, so yes,
Silly clarifying question.
please.
I'm sorry.
That's what
But
you're
this
here
is, it's less legalese and more logistics, just for framing of my brain as we move forward. So for clarification purposes, we in our committee are really only focusing on section 5 and subsections of 5. So we,
Five forward.
yeah, five off.
Five,
correct.
yeah.
Okay, thank you. Okay, so that is helpful. And then I'm I've been trying to formulate the question this whole time. That's why I was like, I don't know if I can put it into words without being redundant. Is what I was trying to do. Is there a way? Because we heard testimony about redundancy. And is it possible? And so I don't, would those things happen, or is there a way for us to clarify any of those questions that it wouldn't be outside of the things like it's pretty, we're only doing those sections and we don't have to. We're not gonna have to focus on,
Well, you know what we would do? We would actually, remember, we can mark this up.
right,
We can change this. We have possession of this bill.
right,
Which means, hey, we can change it.
okay,
Okay. So as part of the markup, I would recommend that we would just strike
okay.
all those sections because they've been added.
Mhm.
What happened is all those workers' comp sections that are in here were added
To 117.
117 over there.
So they're
And
gonna work on
just-
117.
They're dealing with it, so we don't have to.
So
deal with
it's
it.
not going to mess up anything legislatively if we do a strike goal
That's right.
to just,
Or a
okay.
strike of
Thank
that,
you.
yeah.
Okay.
Emily, you have a question?
Yeah, I just want to if folks in the committee do have things that they would like to add or change, specifically, if we could, since that takes some time, just be aware of that, and I guess they would get their amendments to Sophie, so that we could then rediscuss them again, just to be conscious of time that would take some more discussion.
Right, if we start changing the bill, we have to give Sophie a chance to write it up.
Right.
And also, if we make substantive changes to the bill that involve things that we haven't had a chance to hear, we would want to take additional testimony.
Exactly. Thank you.
So, at this point, any other questions of Sophie?
Well, and it looks like this is on the agenda for Friday afternoon. So we would, just for time wise, if we were thinking about how much time that would take, we would be doing that now. Is that what we're saying?
Well, I think that first thing I think we need to do
Before
is
the-
have committee discussion
Okay.
today.
Yeah,
And as a result of that discussion, it's conceivable that we won't have anything for Sophie. It's conceivable that we would, in which case you're right. She would then go redraft and present it back to us Friday.
okay, excellent.
And we can go over into next week if we have to. All right, so committees. Thank you, Sophie.
Thanks, Sophie.
I think it would be good if the committee's okay with this. What I would suggest is that we take each one of the three issues in this bill one at a time. And we ask ourselves,
You don't want me to stay up here, though.
I'd love it if you stay in the room, but I don't want to force you to stay in the room.
That's all right.
So is that okay if we do it piece by piece? And then this is the time for people to say what their inclinations are. Nothing is decided, everything is decided, and so if you want to say, well, preliminarily, I think this is wonderful, it's the cat's meow, that doesn't mean you have to eventually change, you could change your mind, we start to listen to each other. Similarly, the reverse is the case, if you pose something into mind. So I really feel like now's the time to talk about your feelings. So the first one is supervisory personnel in the judiciary. I guess, you know what, Sophie, I forgot to ask you a question about that. Could you review for us which of the, 7 statutes, which ones allow supervisory ones unionized and which ones don't? We know the executive,
So off the top of my head, SELRA, the State Employee Labor Relations Act does. And the State Employee Labor Relations Act definition of a supervisor is virtually identical to the definition that's in the Judicial Employees Labor Relations Act. I mean, again, this morning there was testimony about the very different size between the state employees and the judiciary employees. But so for sure, under the State Employee Labor Relations Act, I don't believe it would be under, you know, the
JELRA does not.
JELRA is not right now, right? That's what this is seeking to do. Under the, you know, the two, what I think of as the quirky ones, the childcare and direct providers, they're only very, I mean, those are really very limited, narrow statutes in terms of negotiating around, you know, what the state reimbursement will be. So that wouldn't be covered by that. And so that leaves the State Employee Labor Relations Act and the Municipal Employee Labor Relations Act and the teachers and administrators. So the teachers and administrators does cover teachers and administrators. So it does cover supervisors in that sense, but it doesn't cover obviously the folks at the very top, the sort of senior management. And the testimony from Joe McNeil was that the State Employee Labor Relations Act and the Municipal Employee Labor Relations Act do not allow supervisory employees. But I have to go back and double check on that.
Okay. So, go ahead.
Can I get the explanation that you would end up having sort of divided loyalties as a supervisor who's supposed to look out for the best interest of the body that you're overseeing? But then if you have, because when, as you were speaking, I remember taking notes that say you can't have supervisors and the people they supervise in the same union. But you just said that this does happen in
Same bargaining unit.
schools.
Right, it's the same bargaining unit. I mean, they can't be in the same bargaining unit. So you can't have in one unit the supervisor and the people that they supervise, because, you know, typically the supervisor is going to be that first line of.
So a unit can have separate bargaining.
Right, an employer can have multiple bargaining units. You could have a supervisory unit, you could have a frontline worker unit, you could, I mean.
Think of a hospital.
Which is not the same as a union.
No.
No, so you can, I mean, again, I would just by way of example, like the Vermont State College System has 7 bargaining units, 6 of which are represented by the AFT and 1 is represented by the VSEA. But then different groups of employees are covered by different bargaining agreements. So you can have multiple units with different agreements. So, you know, you could have one that's a supervisory unit. You could have one that's the folks that are supervised. They could be in separate units.
So is that where push would come to shove, that if somebody is negotiating a contract, is that where I'm trying to like see where, like, show me where the hypothetical of like, oh, my loyalties are divided because I've unionized as a supervisor.
So, you know, I would say based on the testimony from this morning, you know, the difference was drawn between the State Employee Labor Relations Act and the Judiciary Employee Labor Relations Act. And I'm not as familiar with the state workforce, but it sounded as if, you know, there are 10,000 employees and 1,200 supervisors that are in a supervisory unit. But again, there's multiple layers of supervisors. So when you have something that's that deep, you know, there may be low-level supervisors that it's appropriate to have in a bargaining unit. Whereas if you have very few, you're a very lean organization, you have very few supervisors, you know, that changes the balance. That you may have people that, you know, are part of senior leadership, part of making strategic decisions for the organization, et cetera. And those are folks that wouldn't be appropriate to be in a bargaining unit, because they're the ones that are making decisions that are going to be impacting the rest of the employees.
I have a thought about that,
Okay.
I have a thought about that to address exactly what you're saying, and this is just me. What I heard, and then Emily's up there, what I heard was two rationales for excluding supervisory employees. One is that it's just a conflict of interest if supervisory employees are in the same bargaining unit with the people they supervise. But you don't want the supervising employees and the supervised.
Right,
in one thing.
That I
Okay.
can understand.
then I
Why if
asked
they're in a
Joe-
separate,
I know, I asked Joe, wouldn't that be taken care of by separate bargaining units?
right,
So then he went on with the second rationale, which is that when you have supervisory employees, that they're powerful inside the organization and they're hired, that there's a relationship of trust, allegedly, with the management, where they're hired to carry out what management wants, and you wouldn't want a divided loyalty, where they have a loyalty to the union rather than to management. I don't find that persuasive myself. I think that's kind of I'm speaking for myself. I think we heard it yesterday in testimony. Very often labor unions are partners with management in many ways, and that the same could be said of somebody who's a worker on the floor of a car company. I mean, they have responsibility, even if it's not supervisory. They have responsibility to do a good job. If they start messing up on the floor, that's bad for the company. So I'm not persuaded that if you have a separate unit that of supervisory employees, that it would, who are not confidential, they're not confidential, and they're not literally management. I'm not persuaded that it is damaging. I am also not persuaded that these people would ever get themselves a bargaining unit because they're so tiny. Several of them might be confidential employees. Go ahead. And then, well, actually, let me do Emily, because her hand was up, and then you. Emily.
Hi. So for me, as far as committee discussion on this piece, and as you mentioned, Chair, that would be up to the board to decide. But for me, I would advocate to the committee, and I'm happy to get into it more, but my feelings is that I would not like to see any changes to the judiciary supervisor piece. And I'm happy to talk about that more, but I believe that, those questions are up to the board to decide. And I would like to support this piece in the bill. It's very important.
Emily, I just want to make sure I understood. You would support the bill's provision that would strike
that would allow
supervisors to organize, which would essentially leave it up to the board.
That's right. The way the bill is written is how I support
To the
it.
board, yeah. Yes.
Thank you.
I just wanted to piggyback off your comment and make sure I'm understanding correctly. CELRA allows for supervisory. So I guess I'm confused why the reasoning of you would be playing both sides.
right.
Would be the concern for judiciary and not CELRA. Like, am I missing something?
I think neither here nor there, but I think his point was that there's layers upon layers upon layers above the supervisor
Yeah, right.
on that side of things, whereas this side, it's
And
like,
so.
there's two more
one-
people above
one
you and
person.
that's it.
Okay.
Yeah, but what persuaded me, actually, I'm just saying, what persuaded me was, I get the idea that a supervisor employee, I think what that's getting at, Joe, is that a supervisory employee can be like almost management, when they were very powerful and influential and
Yeah.
almost management, but this these people are supervising two or three people like accountants, or they're supervising two or three people doing, guards or other people. And I really want, is that, it's hard for me to imagine how there would have a conflict, I guess.
I mean, it all depends on your organization of how you use what you consider a supervisor, right? Like technically at my work, I bet you could call me a supervisor if you want. I have people that work under me that their work is on me. Like if they do bad, something doesn't look good, basically comes down to me. I'm the one in charge, right?
That's what
So technically I could be a supervisor, right? If they wanted to call me that, but I'm not, I don't hire people. I don't fire people. I don't do any of that type of stuff. So I guess it's kind of how in your organization you structure your supervisor. You could give them a ton of power. You could give them kind of like you oversee the group, and if something's going on, this is who you tell.
Yes.
I also wonder, judging from Harry's testimony, I wonder whether those 4 supervisors are so disparate in their function. They're all supervisors, but they're still, and they're all under the judiciary, but they have it sounds like very different functions. And I wonder whether there's even really much of a point of
Does disparate functions matter? And
That's the community of interest piece, right? So is there, when you're looking at a bargaining unit, is there a community of interest? I mean, does this group of employees make sense?
So does this group of employees make sense, or does the only community of interest mean that their paychecks come from the same source?
It needs to be
They answer to somebody that is in common.
It needs to be more than that. But yeah, I mean, and again, how finely you look at that depends on the size of the unit. So the bigger the unit, the more sort of distinctions you can make, and that's where you might land up with multiple smaller units. But if you have it like for a municipality, if you have a very small municipality, you might have, the police and the, road crew and whatever in one unit, because you've only got so many few people, whereas in a bigger city or something, they may all be in separate bargaining units. So again, it's very fact dependent.
what were you going to say? You weren't done. I'm sorry.
I was just gonna say, I think that's exactly why the board should be making the decision and not us.
Well, the question is, which way right now, the board can't make that decision because they are excluded. If we take supervisory out, then they can go to the board and present to the board.
Right.
Yeah, okay.
That's
Other thoughts, comments, folks? Come on.
My comment would just be the process in which that section of the bill got here. To be fair, to be honest with you, I mean, sounded like judiciary said they didn't testify in the Senate. The members who this would affect, the employees that this would affect, said I hadn't even heard about that. And it just the process of however that got in the bill in the first place seems a little bit suspect, if you ask me. Seems like an odd process to make it into a bill and then pass through the Senate and the Vermont State House.
I cannot tell you whether it is common or uncommon for people to be told, just go away and present that to the House or whatever. I would say it does happen. I think one question to ask yourself is, well, was the testimony here complete? That's I think a key question, but Joe, I cannot tell you how infrequent that is. Others, please. What are you thinking, guys?
I mean, don't we do the same thing when we send a bill out, let the Senate, which usually the Senate does change the bills. And management is never going to be in favor of unions.
I don't think that's true. I think that's a generalization.
I think we heard
I
today they
don't
would
think
be.
they want to have
And I think
somebody
that's a
interfering.
generalization.
You mean sometimes true and sometimes not?
Yeah, I mean, there are several management that are in favor of unions, and I don't think that's necessarily fair as an overgeneralized statement.
Are you saying, Mary? You're saying, of course, they're opposed to it. How are you feeling about it?
That's how I'm feeling about judiciary. Of course, they're gonna be opposed to it.
But you think
The
they're
very-
wrong or right?
The very employees that would be covered being opposed to it, does, I'm still trying to understand
I
that.
don't think they said they spoke to one employee who said, or who was it that somebody said they spoke to one employee who
Right,
wouldn't be.
it was Terry, yeah.
Yeah,
Sorry,
go ahead.
I'm just wondering. So there's 4 people, that if we passed all the other stuff that, oh, that's Celeron, not, this would not. Our certification process, how does that work with 4 people?
They would, they would have to have 3 people sign up.
Plus one,
For an
right?
election, well, yeah, I mean,
Three.
so 50% plus 1 would be 3,
Right.
3 of the 4. Or they could do the majority sign up where, again, if 3 people signed, then effectively, then they don't need to do an election. And then the Vermont Labor Relations Board would look at the unit, verify the signatures, would talk to the respective parties. Because usually there's a representative organization that's behind the union drive. And then, does this unit make sense? Do these, it would, again, assuming it's 4 people, do these 4 people make sense? Or any of them confidential employees? Should they be excluded for some reason? And then there would be, again, the over fragmentation, community of interest. They'd look at all those factors and then determine whether or not that's an appropriate unit. So typically when you bargain, you have a certification from the Vermont Labor Relations Board that says, who's covered by this bargaining agreement. So that language would get worked out at the VLRB.
David, did you have a point of clarification?
Thank you, Mr. Chairman.
Could you identify yourself?
Yes, of course, for the record, Tom Ablemore, Legislative Coordinator, Vermont State Employees Association. I completely agree with what Ms. Zadadny just said in her testimony, and I must say, the concept that there are only 4 supervisory employees in the Vermont judiciary, that is the position of the court administrator, as she stated in her testimony this morning. When a new unit is founded, routinely, there is a discussion that occurs about who would and who would not be eligible for that unit. As Ms. Zadadny said, the board will ultimately rule on who is and who is not a member of this unit. The VSEA, it does not agree with the concept that there are only 4 supervisory employees in the judiciary.
All right.
That's helpful.
So I just, again, and that's all the more reason we would offer that the determination, once we certainly hope that this committee will recommend that 125 pass with this included. And if that were to happen and there were to be an attempt to organize, the board would decide who was and who was not a supervisory employee.
Sophie, I guess that, thank you.
Thank you.
Sophie, how does that work where the board doesn't take something up without 50% plus 1 or?
Well, there's 2 different, there's 2 different approaches.
But how do they do that if they don't know who?
Well, so again, let's move away from 4 employees because that's.
Yeah, right.
Let's assume it's more than that. Say it's 100 employees. So say you had, so the organizing entity, so the union, whoever that may be, representative organization, can one of 2 approaches. So if they think there's 100 employees that they think, could be in this unit, they can either get 30% of signatures that then would lead to a secret election where you have to have a majority of people vote in support of being represented by that organization, or the majority sign up where if you had 50% plus 1 of those individuals. So again, under the hypothetical of 100 employees, if you had 51 employees sign a card to say they wanted to be represented by this particular organization, then again, the VLRB would go through, check, verify the signatures. And again, usually this is kind of a process that's worked out with both the the representative organization and with the employer and with the VLRB to kind of work through, you know, who's in, who's out, you know, who might be a confidential employee, how many people qualify as a confidential employee. You know, is there anyone that's missing? Should it make sense to include this other group of 10 people over here? Should they be included in this unit? So that all is a sort of conversation that happens at the VLRB. If there are disputes, then you land up with a hearing, and the board itself makes a decision. The goal again is always to try and get the parties to resolve these issues on their own. And as I say, the board, the VLRB issues a certification of who will and who won't be moving forward.
So in the unlikely case, I assume it's unlikely, but just to clarify, in the unlikely case that they get cards from 30 people saying there's 60 of us, or 30 saying there's 50 of us, and then as they investigate it, and perhaps management is the one who asserts, no, there's not 50, there's 100.
Right.
So you need more signatures. They would just send it back for more signatures.
Well, yeah, I mean, if it's majority card sign up, but again, if it's 100 and you have 30 cards.
Well, okay, 110.
Do it, right.
And they'd send it back. Okay, you had a question.
No.
You had a question.
Thank you. Okay, because I have the really most basic clarifying question, because we've gone around. I've confused myself at this point. You keep saying included, excluded bill is, okay, so where it says a managerial, supervisory is stricken out. So when we say included, are we saying to put that back in, or are we saying to leave it stricken out?
We want to keep it.
Thank you. Okay.
That's what we're talking about.
I'm like, wait, like y'all are confusing me now.
No, but I think it's good. I think it's really good that you say that. Let me try to put this neutrally. Because, you know, it's one of those things, if you don't know, you mean yes.
Right.
Yeah,
Like,
right.
wait a minute.
Okay. This draft of the bill is looking at a list of people who are excluded from the definition of employee.
Yeah.
This list of exclusions means if you're in this list, you can't organize. And the list includes a whole bunch of things like managerial employees, the court administrator, a judge, all those people. It also happens to include supervisory people.
Right.
If we did not pass this bill,
Right.
we just left life as it is.
Right.
Supervisory people would be excluded from the list of employee, and they could not petition to become a bargaining unit.
Okay.
If we pass the bill, we're striking supervisory. We did that. They could petition the board to organize.
So if it's everyone else still cannot, but they would be able.
They would be, well, the ones on this list could not.
That's what I mean.
Yeah.
Everyone else on this list would not be able to, but they would. Okay,
Yes.
thank you. Sorry.
I just had to ask, what's the difference between a supervisor and a manager? So, you know, that's okay.
Okay.
So others, what do you think? What are your guys' views? Huh?
I have thoughts and
Yes.
questions. One, not that I am trying to get rid of you, Sophie. It is 3:08. So,
I'm good for probably 10 more minutes.
okay. I have a few questions or like comments and thoughts. So bear with me. I had asked Tom how many they thought would be considered. And I mean,
And that, of course, is a rough estimate subject to the determination of the board,
yeah, absolutely. Ballpark. And you had said a few dozen.
but potentially.
Okay.
But did Tom bring us cookies?
My girlfriend who's testified before this committee, Johanna DeGraff.
She didn't bring us
She
cookies.
has a Cuisinart mixer, so I am happy to get.
Sorry, that was totally inappropriate. I'm so sorry.
Okay. You just surfaced what everybody's thinking.
So I have, I know we had brought the VLRB in for testimony. And I don't necessarily think we need testimony from them on this specific bill. I think as a whole, I'm concerned about benefit property. Because when Steve was in earlier, he was saying that, you know, like just the ability to create a unit and is, several years out. Or I'm mixing my words, but like there's the capacity issue and I'm concerned. Not necessarily that this one change is going to create an exorbitant amount of work for them. But I think, I just, as like, put a pin on it. I think we need to talk more about the VLRB and what their role is and what their capacity is.
I would just add on the VLRB, there are very strict timelines currently in the statute around unit certification, and those kind of jump to the front of the queue.
Yes. It's grievances that are.
Right, there are other things that then get backlogged.
And I think, it's just because we keep hearing about, well, it's the board's decision, absolutely, but it sounds like the board's really bogged down. I did have a question, not for you, Sophie, but for Tom again.
Happy to help if I can, Representative.
Great. Were you in the committee when Kelly Price testified?
I was, yes.
Would the VSEA would you approve or would you be supportive of that amendment?
So our Board of Trustees has taken a position on this legislative initiative.
When you say this, S-125 or specifically?
Specifically I'm sorry, I mean, interrupt, but specifically, yes, the amendment
Okay.
that you're referring to,
Yep.
and Mr. Price spoke in favor of. And our Board of Trustees voted unanimously to oppose legislative language that would create the bargaining unit in the way that was described in this proposed amendment.
Is there a reason why?
There is. So, and I'm happy to, I don't know if it makes sense to, are you interested in hearing that testimony at this time, or what's the most helpful for the community in terms of this process?
I'm really wondering whether we shouldn't take this up separately. What do you think? In other words, I'm not saying separately apart from this bill. I mean, whether we shouldn't go through the parts of the bill that are here and then take this up. We want to talk about it. And Emily was saying earlier, hey, there's others out there and there has to be, I think we have to think about process on this.
Sure.
Right, that's what I was saying. If we talk about process that many of the committee members have advocated for, then all things need to be considered, not just something that was added today.
BPR. Sorry.
So, others? I mean, how do people feel about this piece?
We're still on
Yeah.
section
I'm
5.
trying to draw out. I would support this piece. I'm gonna try to encourage. I'm just saying, I would support this piece. I'm not persuaded that it would be damaging to the courts to have supervisory personnel excluded. I mean, to allow supervisory personnel to go through the process of the VLRB.
Yeah.
I mean, I don't know what the VLRB will do, but I don't see a problem there.
Yeah, it
I'm
was
not
helpful.
persuaded, I'm just not persuaded that generically supervisory employees should be excluded. I could see that the VLRB might say X number of you guys are managerial or you're confidential or whatever, but I'm not overwhelmed by the supervisorial category myself. That's just sort of where I'm coming from. Anybody else want to express themselves?
Yeah, I'm a no in this section.
You're a no on the section. Okay, others?
I agree with what you had just said.
I'm trying to get a sense of this because then I want to see where we are on each of these pieces and I'm willing to move on despite the fact that nobody's talking except Joe and me and you.
I will say I'm fine with, and let me give my justification. So hearing all of the testimony today, it's hard to understand both, I can hear both sides, right? Like, this doesn't make sense. Why would you do this? Yes, we're doing this because it's checks and balances and it makes sense. And I often like to err on the side of caution and say, we don't know that folks will even unionize. However, I'm gonna err on the side of, I would like them to have the right to. If that was where the case may need, and there need to be. I would like to lean on the side of better to have it and not need it than need it and not have it. And so for me, that's I'm okay with this. After hearing all the sides of the testimony, I think that's where I stand on it. I'm okay with it.
Mark,
Yo,
hey. As I mentioned, I feel very strongly about this piece and you know, as we pick apart pieces of the bill, I want to also make sure that maybe people aren't going to vote for the entire bill as a whole, and that's fine. But I'm not going to like try to make it peaceable to people and then have it just not be. So, as far as I'm concerned, if we're taking things piece by piece, this is a piece that I feel strongly about as part of the bill and is not a place that I personally will be it's as strong a part of the bill as the entire bill. So I'm not gonna pick it apart and then wait for the whole bill. That's where I stand on it.
yeah, I mean, Emily, what I'm gathering you're saying is, yeah, I support this piece, but I support the whole thing.
That's right.
Yeah, okay. Others?
I I support this section of the bill, and I do also support the VLRB and their decision making, which is as I was saying to a couple of people earlier, I don't necessarily believe that everything needs to be in statute, that we can trust people we've appointed to make decisions.
Others?
I just have a question. I mean, once, like, we were talking about a group getting together and then you were like, might be like 10 over here that could join that group. Can they join later on, or does it have to be done while that group is being put together?
It's generally much easier if you do it at the beginning because then you have that official certification, but certainly there are situations where, groups may seek to join an existing union or break away from an existing union. I mean, those things happen, but it's ideally you would, both sides, that would be interested in making sure you've identified all the people that have a similar community of interest and you've got them all in the same.
The positions, right? I mean, if you have
Positions.
yeah, one person leaves, another person comes in, it's the positions that have been, yeah.
You mean in terms of the leadership of
No,
the union?
no.
Just generally.
Let's say you have 100 people that have, they don't certify John Doe, they certify the position. John, whatever, supervisor to working, I don't even know how it's done.
Oh, I thought you were asking about in a unit.
No, it's in the unit, in the burger.
Got it.
Others? Yes.
So I'm very hung up on the word supervisory, number one. And I want to make sure that if you're voting for this bill, that's striking supervisory.
As an excluded.
As an
Excluding it.
So that means in putting it back in so that they are included.
It means that they would be able.
They would be able
Okay.
to bargain.
Okay. So when it says managerial and also supervisory, there's a big difference between that. So when you're a supervisor, you may just, point the person in a direction, this is what you do, but you don't have hiring and firing power. So that concerns me that I look at that as kind of equal to an employee. You're just, like what Joe said, he doesn't have the title, but he's supervisory to some people, but he's not the manager that can hire and fire someone.
I would just note that in the definition of a supervisory employee in the Judicial Employee Relations Act, it does say an employee as determined by the board who has authority from the employer to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline. So
Is that
supervisory.
typical?
Yeah, that's the definition here. It's also the same more or less the same definition as what's in the State Employee Labor Relations Act.
They supervise but they could hire and fire.
Yeah, it does say hire and fire.
What is a manager?
So a manager means an individual as determined by the board who functions as the head of a department, institution, district operation, or a major program or division or section. I mean, that's the very top.
Supervisor is.
But supervisors also do have the power to hire and fire and discipline.
So I would think, for example, if I was a supervisor in an accounting division, forget about the confidentiality. And I had 3 employees that I managed, and I could go. If I can't, is there any difference if I can fire people or just recommend that they be fired?
I mean, it depends, but I mean, the definition, so if you were to say supervisory employees can organize and collectively bargain, and given the way the statute is written, that means employees that do have those powers would be able to organize and bargain collectively.
Okay.
So yeah, just wanted to be clear on that. That's why they can't be in the same unit, because if you're disciplining somebody or you're firing them, you know, the person that's the subject of that would well have a grievance, and, you know, they're in the same bargaining unit, which is why they have to be in separate units.
Right.
Can I look at that paper? So I can just see it visually? Sorry.
It's the same definitions. What you have in S-125 is just an excerpt of that particular statute.
Yeah, I want to see it clearly. Thank you. Without all the extra.
But in that definition for supervisor, it uses the word or, so they may not have all the powers that are
Right.
listed.
You should be a supervisor and not have hiring and firing authority, right?
You need to take off.
I do.
Okay.
Thank you.
Thank you.
Thank you, Sophie.
If we have further questions, we'll save them up and get you back.
Yes, I think I'm maybe scheduled for, is it Friday?
Okay. I mean, we'll just keep going for a while.
Okay, and I can try and catch up.
Do others wish to express a preliminary opinion on this issue?
I don't feel strongly either way on this instance.
Putting you in as a maybe.
Right? Never know.
Luckily, in a couple of years, we won't have to worry about any of this because we'll all be able to go and get their answer whether they can or not.
You mean because of PR3?
Correct.
Okay, anybody else? Okay, anybody else? At this point, no one else wants to say. Okay, by the way, like I said, you can always change your mind. Okay, so the next.
Thank you, Sophie.
Thank you, Sophie. The next part is 50% plus 1. This is the one I'm gonna attempt to simplify. This is the one that says, right now, as a general matter, I'm not going to be super precise. If you want to organize a union, I mean, a bargaining, if you want to organize a union representing you, not organize it, if you want a union to represent you, is it only a bargaining unit or is it the union as a whole?
I'm gonna be honest, I'm not entirely sure
Bargaining.
how you are explaining this. This is the decertification.
This is the decertification.
Right, but
I'm
he's
just
saying if you want to
But it's the
compare
certification of a
bargaining.
bargaining unit, it's a
Bargaining
bargaining,
agent.
yeah, okay. So To
The bargaining
certify,
agent, which is
you can either do it 30% signatures, or you can do 50%, more than 50 card check. And if you do 30%, you gotta have an election. If you do 50% card check plus card check, it's done. Okay. To decertify, right now, you just need 30%. So I say we want to decertify the bargaining unit, and then it's forced to an election. So the position that led to this bill is we would like to make it more difficult to decertify, because and I'm saying this is what we heard, that it's more, we want to make it more difficult to decertify. We think 30% is too little. It's not hard to get 30% at any point of people who oppose the union and oppose the bargaining group. And this has we may win the election, but it has the effect of forcing us into elections. And by the way, voters include people who aren't even in the union. So they want to move it up and argue that it doesn't matter whether they're parallel. We don't want them to be the same. We don't want them to be the same. So yes, you take over. Where?
So it's different than the election. So like this process looks different, right? Because I imagine an election is like a one-time moment in time. You better get yourselves there to in person. Is it secret ballot, the 30% election? Versus this is a petition with signatures that they're saying will be 50%.
I think there are individuals in this room who are more qualified to answer that question.
Many years worth of labor law, I think, and doing a poor job because it's happening live and in committee. But yeah.
Thank you, Ms. Chair. So the nature of the way that an election often will work, it's not necessarily, although there may be in-person voting, it's not necessarily only show up on Tuesday between 3 and 4.
Okay.
Once an election is triggered under the statute, there's a date set by which the voting for the election will commence and end. One of the acceptable voting methods can be the submission of a vote by mail to the Vermont Labor Relations Board, where you send in your ballot. In-person voting is possible in some cases as well. But again, your point is, I think, a correct one, Representative Dutch. We're talking about, in this instance, what is required as a showing of interest in order to trigger a decertification election. And trying to make it similar to the process that legislators are familiar with it from their campaigns. It would be like in states that have recall elections. It would be like getting the required number of folks to sign on to trigger a recall election.
Mm-hmm.
And then after that point, the election is held. They announce the day the election is going to be, how you're able to vote for that, and then people can vote. So as it stands, only 30% of folks in a bargaining unit are required in order to trigger that decertification election. And then later on down the road, the election is held and folks can vote in terms of what they think they should support. A majority is required to win that later election.
Okay, so this is the petition to have a recall election.
Exactly right. To have a decertification election, which is just like a recall.
Is the 50% plus one?
Is
And then-
signatures to get
Sorry.
call an election. It's not the actual vote.
So when the vote happens, that's 50%.
Under current law, that's right. And under law, if you guys adopt this, if the members of this committee recommend that if this comes into law, yes, Not what will not change under this provision is what's required in order to win that
Okay.
election. That will
Now I
not change.
understand.
Only what would, the only thing that would be changed is what would be required in order to trigger the election.
Yeah, okay.
Chris, did
I
you
needed a
want to
flow
add
chart.
something? Slash, can you please
Just-
provide your name for the record because you haven't said anything today?
Yes, my name is Chris Hoare. I'm a labor representative as well. I work for the New England Police Benevolent Association. I was not here to speak on this topic in particular.
You have homework in this committee.
But I am pretty familiar with the process. As it relates to winning the election, it's only 51% of the people who actually vote, not 51% of the entire bargaining unit.
Oh.
Correct.
I also, my understanding is the system.
Roll that back, say that again.
So just like our elections.
It's 51% of the
Of
people who
voters.
actually vote.
So apathy can't
So by not voting, you're not.
give you no votes, like not voting is not a no. Or, yes,
Oh, so it's not part of the membership
it's of the voting members.
of the
It's
voting
of-
members.
It's of the vote, of the members of the bargaining unit who actually vote. You don't have to vote. So let's say you have a bargaining unit of 100 people. And only 20 people vote. You need 11 people to vote one way or the other.
And that's strictly the election,
That is just the
not the
election.
certification or decertification. Certification, decertification, you need all of the bargaining unit, anybody who would be eligible to vote.
You just need 30% of the
Yes,
bargaining
right,
unit
right.
to show what we call a show.
But that
of
30%
interest.
is lower because it's actually the like, it's a big number of
30% of the
people.
overall unit,
Yeah,
that's correct.
it's- okay.
As opposed
So
to.
you might not even get 30% to actually vote.
Yeah, right, so it's a
But you
big,
could
big
have
effort.
everybody vote. So.
And in a hypothetical situation, if it's 30% of the unit and it's individuals who aren't in the union or don't support it,
Yeah.
there's a good chance that that 30%
I
is
don't
going
think
to.
anybody could vote or sign a card of interest that is not part of the bargaining unit.
Oh, no, wait,
Yes,
wait.
No,
to
but
your
in terms
point,
of
Madam
people who
Vice
are
Chair,
certified,
you're
correct.
exactly
In the bargaining
correct,
unit.
Madam Vice Chair.
Who
Okay.
don't
The
want a
30%
union.
of people who are not, let's.
Are going to be more apt to, and like this is an assumption, and you know what, I get
You're
that,
exactly
but
correct.
I'm
That's what I'm
assuming
saying.
that people who might be upset that they belong to a bargaining unit might just say, let's decertify.
Speaking only in generalities, I don't think it's a huge stretch that you did to assume as you are.
Yeah,
That folks who are not a member of a current, who are not currently a member of a given union might be more likely to support decertification. I don't think that's a crazy stretch.
But they can't vote.
They can vote to decertify, they can
They can vote both to decertify the
and
unit
decertify.
and they can vote in the subsequent election if an election is triggered. That's right. Any member of the bargaining unit can vote to decertify the current union, whether they're a member of that union or not. And then in the subsequent election, every bargaining unit member, again, whether they're a union member or not, gets to vote for, let's say, Union A, Union B, or no. So those, whether or not one is a member of a union, does not affect whether they can vote to decertify a unit. And it doesn't preclude them from voting any way that they choose in the election that's held.
yes.
The only question that I would ask the committee is, why would we make it more difficult for employees to exercise their rights?
What's your, what are you saying with that?
Because the amendment, in my understanding, is we're increasing the amount required to effectively change your bargaining unit representative. You're making it harder for employees to exercise their rights.
Of course, the VSCA would argue that one of the rights that an employee has is to be a member of a union where they can join together with their fellow union members to advance their collective interests in better wages, better benefits. And I think that if we're talking about what is actually disruptive to one's right to enjoy those protections, a constant slew of decertification elections triggered by only 30% of one's colleagues in a bargaining unit is the more pressing concern. So we would, of course, disagree with the NDPBA on that.
So having that that information. And we do not, like we said, I'm sorry, Magali, I'm refreshing before I say anything. We will be talking about this again on Friday afternoon. And of course, you know, there's time tomorrow, but does anybody feel strongly one way or the other about this portion of the bill, which is section 5A? That feels like they want to share their thoughts at this moment. in
So
time.
we're not voting it tomorrow, we're voting.
No, so the only,
Friday, because we
we're
added
not
Monday.
voting at all, like this week. So for the
Oh, I'm
plan,
sorry, that was Prop 3,
yeah,
sorry.
so tomorrow is going, we're going alone. Really quickly as a recap, tomorrow we're gonna be voting on Prop 3. In the expectation that it will most likely pass our committee, because there is a want for it to be on the floor on National Workers'
So
Day,
we
which
need
is May 1st. There
Friday,
needs,
Monday,
because it's a
Tuesday,
proposal,
Wednesday.
it's 4 days on the notice calendar. So what will happen is on Friday, the speaker will ask for a token session on Monday. And for new members, a token session is, it's just passing a legislative day. So Monday would then be considered a legislative day. So then it would be Monday's the first day, Friday's first day, Monday's second day.
Tuesday, Wednesday.
I was like, where's the other day? Tuesday is the third day, and then Wednesday would be the fourth day for proposal 3 to then go on action calendar for Thursday, May 1st, National Workers' Day. For this bill, we are still taking testimony, having committee discussion, and potentially markup if there's changes that we want to see made or not made. So we will not be voting on this bill this week. Tomorrow, we will be focusing on S-127
And
for
169.
and 169, and that I keep putting those together.
Yeah.
because
Oh, yeah,
Um,
that section.
Yeah, so that's how the rest of the week will look. So we will have more time to discuss this specific bill on Friday.
Okay.
Anybody have thoughts or feelings about this section? That's okay. We don't have to share our thoughts and feelings.
This is clearly not my area of expertise, so I'm gonna take the time to soak it in before I have it.
Absolutely. I support
I just think, yeah, you can spend time.
I don't think we need hands. We can just share our thoughts and feelings. Except for Emily, if you do have thoughts and feelings, please at least give a nod or say you want to say something. Go ahead.
Besides wishing I was feeling better, I am grateful for this conversation and we'll have some more thoughts and feelings at the later discussion. Thank you.
Great. Elizabeth.
I can't, I don't think, any argument against this that I can think of does not hold up.
I'll just remember that.
We'll be
Okay,
talking about this another time anyway, so it
Yes.
doesn't matter.
yeah, and
It
then
doesn't really matter what I think anyway.
it does. It does.
I know, I'm just kidding.
You are very persuasive.
I know, at this point, I like just kind of try and guess what you're gonna say, just because it helps me. Can just to round out the rest of the conversation and the rest of the afternoon.
On this section, or,
I was just gonna say on the last section, unless there's more you want to add on this section. Because
it seems really lopsided to, I mean, it's lopsided and which is a problem. To have it be 30%.
I think if you remember last year or 2 years ago or whatever year it was, both Joe and I were saying it should kind of mirror each other.
Yeah.
So we've definitely not the first time this has come up.
Yeah, at 50 and 50?
Mhm.
Yeah.
So when we did
Yeah.
the car check, that was really our main concern was, why is it one way or the other? So yeah,
And the other part of it is it's not making it more difficult because when you think about it, it's not even members. It can be non-members. That's a disadvantage if you're on the other end of it. What do you call it again?
Decertification.
Yeah, decertification. That's more of an advantage to people that are non-members, that are not part of the union.
do you have testimony that you would like to provide, maybe in writing or?
It's not more of a clarification. Not important on that.
Okay. What do you?
I just want, actually, it's a question for these guys, I just want to.
Yeah, no, absolutely.
So. You mentioned that it is not implausible that repeated 30% petitions can be deliberately disruptive of, and it distracted from.
That's fair, yes.
Okay. Is it happening? I know it's conceivable, but does this happen frequently enough to?
I can say that we, the VSEA, have faced repeated raids over time, which are attempts to provoke a decertification levy.
Sorry, with raids, RAIDS.
It's a phrase used within.
It's a business.
Not immigration.
Oh, well, yeah, sorry.
I'm sorry, I should clarify, especially in the present context, but yes, no, we've faced several attempts to decertify our units, I should say. And that is also a trend, and speaking with some of our colleagues throughout the country, that they are seeing as well.
Can I ask a follow-up question? Because now I'm very confused.
Yes.
When Steve was in here earlier today, he said that you can only decertify during open time?
Open
Period, thank you.
period, yes.
But that's only every 2 years.
That's correct. That's correct. But I'm just saying, the question is, have there been repeated attempts? Have there been ongoing attempts?
So
Yes, there have been repeated and ongoing.
Okay, so, but it would be like every 2 year attempt. It's not every other month.
Every 2 years with regard to a particular bargaining unit. That's right.
Okay.
Of course, there might be, most labor organizations or manual labor organizations represent multiple bargaining units.
Okay.
It would not be uncommon or necessarily, wouldn't be surprising if this issue played out across several bargaining units might have a more frequent timeline of having to be involved in an election than every 2 years.
I have a question for the committee really quickly. I don't feel like this conversation, it's almost 4 o'clock. I think some of us have other meetings that I have to be in specifically for me. So I am somebody else who has another meeting. But that being said, I think I have more questions and I feel like I might not be the only one at this table. And if I am willing to be that one.
It took us this long just to understand what a manager versus a supervisor is.
Do you have availability later this week or next week
Sure.
to discuss, and I can have Magali reach out to you?
The VSEA will always get this up.
Don't say that, you're gonna be in here all the time.
I already had that.
Depending on whether I have bargaining or some hearing or something along those lines, I do my best.
Okay, perfect. Sorry, go ahead, Tom, or Discom, not, Rep. Charlton, go ahead, I think you had another question, I'm so sorry.
Thank you, Madam Vice Chair. The 30% is just triggers an election.
Correct.
The 50% plus one is still the standard for actually making the change.
That's correct.
So I can see where it's disruptive, but I can also see where it makes the decision-making process accessible. Just to initiate, I can see where it can be played, be disruptive, and I can see where it does provide a threshold to start a conversation that's maybe easier to achieve than.
Yeah, of course. I mean, certainly our opinion would be that 50% plus one threshold to trigger the conversation. In our opinion, this is of course, VSCA's first assessment. In our opinion, 50% plus one is not an unreasonable standard to ask folks.
Well, demonstrate that standard is probably over.
I'm sorry?
If it does hit that standard just to start the conversation, you can pretty much tell where, you know.
There's a campaign after that, but it would represent, I think you're absolutely right, Representative Geraldine. It would demonstrate a real concern on the behalf of the members of the department. And one that we think it's,
Yeah, I'm not sure what other states in New England, for example, have for a card check for decertification. I'm familiar of it with certification. In my understanding, with the card check process of the 51% that was recently passed is not for, it's only for new bargaining units who do not have a labor representative. So if a unit is trying to change their labor representative and they currently have one, they cannot utilize the 51% card check.
in my opinion, it Representative Geraldine, if you were asking about the 51% in the subsequent election itself.
Yes.
That's what you were referring to, not anything having to do with the contract.
I know I'm gonna have a question.
That's fine.
I have a question that I'd like to put a pin in.
Pin-in, yeah, I love pin-ins.
For another day. Oh, can we think about, so we know that it's 50% plus one for what we're talking about for decertification, but it's also 51% for
Election?
yep.
Choosing, yeah,
50%.
Can we just make that one or the other? Do you guys care?
I'm sure they.
I would say that it's meaningful because there's layers to it for a reason.
Okay.
So, like the representative, said just a minute ago, one is, a standard to reach in order to start the discussion. Another standard is to
Make it.
win the day or move.
Yeah.
And I don't know that.
We can offer testimony when we come back.
I'm sorry.
It sounds like we'll be testifying later on.
Well, it doesn't.
I think it's a good
not
point.
important.
No, I think it's a good point also.
But it's a good, I mean, it has nothing to do with the. That's
It's a big pin.
I think it's a holistic approach to the conversation. So I think.
That's for the holistic approach to the conversation.
Oh.
I think.
I would like to have a conversation about 50% plus one versus 51%.
Well, and I
One
think-
is a different number.
It's a totally different number.
And I think this is the time to do it. I'm not Betsy Ann, but I am positive she would consider that germane.
Yeah.
So I think this is a good time to do it. Are there any other comments on this section?
Well, I mean, somebody did testify that it was 50% plus one person.
Yeah. So I think we're looking at.
Originally, to get there, but when they vote, it's 50%.
51%.
So I think we need more,
We'll clarify it.
yeah, we're gonna have more testimony, more clarification.
I mean, I guess for me, the clarification would be,
Why two different things?
why two different things? Why 51%? I mean, 50% plus one is like $19.99. You know,
That's all.
what?
Well, that's because if you have 1,000 members, 510 is 51%. 501 is 50%.
That's right.
plus
That's
one.
exactly right.
And that's.
And like if you were getting your petitions filled, if we're gonna keep it to elections, we're getting your petitions filled out for an election. That can, depending on the size of your town, that can make a really huge difference.
Yep.
So definitely, we will have more conversations. If Magali hasn't already sent that email, maybe she could include that question there. Briefly, the last section, that is our certified payroll. I certainly have thoughts and concerns, and I think more committee discussion is needed. I think Mark also has questions and for more discussion. And seeing as we are now missing a few of our members, are we comfortable with wrapping up for the day and finishing this conversation and more testimony or discussion later in the week?
Yeah.
Great. Fantastic.
Is there other type of testimony that we could take?
On which aspects?
Right now.
Oh, no, right now.
No.
Do you mean on the specifics of this bill or adding something else?
I meant on the, this last section.
Oh, my gosh.
I'm sure there are, and we can, if you can think of somebody, or I'm sure we can ask for more testimony. Maybe we can see if we can get somebody through NCSL from Massachusetts. Or Maine, question mark, with Maine for someone. But yeah, I think we can definitely have more testimony.
Do you think we could have testimony from workers?
Yeah.
Who have experience in the future, but like prevailing wage.
Can you help us with that?
Yeah.
Thank you.
I really love that. Thank you.
That is something we will work on. Magali,